Members of the press, in front of you are representatives of 7 organizations that have filed a case challenging internet shutdowns and interruptions in Kenya. I am representing International Commission of Jurists. We have representatives from CIPESA, representatives from Paradigm Initiative, and representatives from Bloggers Association of Kenya. I'll proceed to read the statements alongside my colleague, and then we will answer some questions and give further guidance. 7 organizations have today filed a landmark public interest case challenging unlawful disruption of the internet access in Kenya. The organizations are the International Commission of Jurists, Kenya Section, the Bloggers Association of Kenya, Paradigm Initiative, Kenya Union of Journalists, Katiba Institute, the Law Society of Kenya, in collaboration with collaboration on international ICT policy for East and Southern Africa, also known as CIPESA. This legal action responds to credible evidence of deliberate interference, including internet throttling during the 2024 Gen Z protests and blocking of social media platforms, Telegram during the 2023 and 2024 Kenya Certificate of Secondary Examinations period. The evidence of the internet disruptions for this case was provided by Cloudflare, IODA, the Open Observatory on Network Interference. The restriction of the internet in Kenya on 3 occasions, 2023 and 2024, constitute a blatant violation of Kenya's constitutional rights to freedom of expression, media freedom, access to information, as well as the full realization of economic, social, and cultural rights. The 7 organizations have sued the Communications Authority, the Cabinet Secretary for Information, Communication, and Digital Economy, as well as 2 telco providers, Safaricom and Airtel. As organizations committed to defending civil freedoms, we condemn the escalating use of digital repression to silence dissent, manipulate information flows, and erode democratic participation. Kenya's obligations under the African Charter on Human and People's Rights and the International Convention on Civil and Political Rights, as well as our Constitution, reinforce the imperative to protect digital rights in Kenya.
Thank you, members of press. I'm Kennedy Kachwanya, representing Bloggers Association of Kenya. The internet is no longer a luxury, but a critical enabler of political discourse, economic transactions, and even emergency response systems. Any restrictions must satisfy a stringent legal test under Article 24 of the Constitution, which are legally necessary and proportionally standard. I repeat that any restriction must satisfy a stringent legal test under Article 24 of the Constitution of Kenya, which are legality and necessity for the proportionality. So it has to be proportional. If you are going to shut down the internet, it needs to be proportional, and there has to be a basis for doing this. So through this case, the 7 organizations are seeking a judicial declaration that internet shutdowns without due process are unconstitutional abuse of the state's power, alongside the court-ordered mechanism to ensure that oversight, transparency, and accountability in digital governance in Kenya. The outcome of this case will have far-reaching implications for millions of Kenyans who rely on important connectivity for their living and civic engagement. We call upon civil society, media partners, and the international community to amplify the crucial fight for the digital rights as the cornerstone of Kenyan democracy going forward.
So
Thank
you're
you.
right that the internet and access to the internet is so fundamental, especially during times of crisis, because it does not just air the violations within the country, but also outside the country. You remember when the internet was shut during the Gen Z protests on 25th of June, a few other jurisdictions around Kenya also experienced a bit of internet disruption and internet shutdown. Uganda, Burundi, and a few others, and that is just one of the mechanisms to curtail, information getting out to the international community. Why? Because a lot of authoritarian regimes do not want their dirty linen exposed outside. So the more we have access to the internet and access to information, it means that a few other mechanisms and frameworks and the international community is aware of what is happening, and I think that's why a lot of again, authoritarian regimes tend to switch off the internet as and when there's a few, mishaps just to control information out there. So this is one of the things that we are condemning in the strongest terms. I do not want to be a prophet of doom or a prophetess of doom, but that is exactly why we are filing this case, because and it has been recorded. You also have records of, different people in government saying that the internet needs to be shut down, and so that's why we are filing this case at this particular point, a couple of months before elections, years before elections, so that we have legal precedents set. By the time we are getting into the electioneering period, at least we have legal backing by that time. So yeah, you're right.
I would like to add the fact that this is a trend-setting moment for Kenya. For countries like Uganda that have done this exercise before, and you find a court of law derailing the whole process until it is overtaken by events, we would like to see Kenya do different. We would like to see the judiciary of Kenya coming up to protect and stand by human rights and protecting its citizens. By sort of starting this trend and showing that the East African region can do better, we are very expectant of this. Thank you.